Hello, everyone, and thanks for tuning in to our talk tonight. A TOLATA case update given by Desmond Kilcoyne and me, Jeremy Hall. The timing, I suppose, is fortuitous given that it's the last evening of lockdown. I suspect there would be other attractions tomorrow night, unless you live in Kent, of course, or the north of England, when I think you're going to be in tier 3 forever and consigned to watching TOLATA case updates on a loop on YouTube forever, maybe, I don't know. Our format tonight is straightforward. Desmond is going to speak first and take you through some of the recent cases with perhaps more of a civil commercial context. And then I'll look at some of those cases with more of a family dispute-based emphasis. Although, of course, there is a significant crossover in many of these cases. So I'm now going to hand over to you, Desmond.
Thank you, Jeremy. And good evening, everybody, from 42 Bedford Row. This evening, we're doing a case update, as Jeremy has said, and I'm going to do the area slightly less focused on the core case of the matrimonial or the quasi-matrimonial home. I'm going to do things that are slightly around the sides and that are verging into similar sorts of arrangements or investment arrangements, things like that. And in particular, I'm going to deal with I'm really going to break it down into 3 main parts. The first scenario I'm going to talk about is once you're on the road to trying to get an order for sale, and the issue comes up, whether it's your client or the other side, the issue comes up whether one of the co-owners can buy out the other co-owner. That's the first issue I'm going to look at. The second issue is, again, it's a classic ownership stroke co-ownership scenario. It's where one person has facilitated another person essentially getting a foot on the property ladder. One person has taken a property in their sole name, taken out a sole mortgage, but it's on a clear understanding that everything is done as a bare trustee and that the true owner will be the person who is actually living in the property and who inevitably is probably paying money over to cover the mortgage, doing improvements, paying all the relevant sorts of outgoings that are characteristic of property ownership. So that's a second scenario that I'm going to deal with, neither of which, of course, are pure on the pure question of the quasi-matrimonial home. And the third thing I'm going to do is I'm going to discuss 1 or 2 other interesting cases dotted around. I'm going to touch on occupation rents and also the question of whether an order for sale is made or not in a contest with a trust document that seems to suggest that there should be no order for sale, 1 or 2 recent cases. So I'm going to start with the first of those, and it's the case of the co-owner who wants to buy out. I'll refer to this loosely as the right to buy out, not the right to buy, but the right to buy out the other co-owner. That's a situation that's a classic TOLATA situation for obvious reasons. The sections we're thinking about here are sections 14, which is the section giving the court powers to make orders in relation to trusts of land, and section 15, which are the factors that are set out under the Act, which a court must take into account when they're considering what order to make in relation to the land. The problem is, in the case we're looking at, when one wants a right to buy out the other co-owner, problem is, how do you ensure that the price that's going to be paid is right, is fair? And of course, we have the well-known case of Begum and Hafiz from 2015, which laid the ground on that and highlighted that, of course, trustees and indeed the court do not, and this is a slightly technical point, they don't have the right to force one beneficiary selling their equitable share to the other Formally, this is done by way of one beneficiary buying the whole property. It really amounts to the same thing in practice in terms of the money exchange, the result. Formally, it's one of the co-owners buying the whole property, rather like a buyer on the open market. So what are the mechanics for this? Of course, the property could be put on the open market. That would be one way of doing it, and simply allowing the interested co-owner to purchase it. I've no personal experience of that ever occurring, but one can foresee the sorts of problems that might arise. To start with, the bids for the land, the interest shown, might be affected by false bidding, trying to artificially raise the value of the land, obviously, potentially, by the co-owner who is being bought out. So artificial inflation is one problem. Another possible problem is that even if there isn't artificial inflation, for various reasons, the price may exceed the anticipated market value, in which case there is then the question of whether the court contemplates that the buyer should still have a right to buy out in circumstances where they're being forced to pay an unanticipatedly high price. Both of those factors, and no doubt other factors that you can think of, make the whole of that type of mechanism a problematic mechanism. And the answer is that the court have accepted that it's acceptable not to go to the market during this process. What you do is you simply identify with expert valuers what the open market value is to start with during the dispute, and then the court can give the interested co-owner the right to buy out at that price as valued. And that seems to be an entirely uncontroversial way of going about it, save insofar as the issue of valuation is concerned and whether you've got the valuation right. Obviously, either side may take issue about whether the valuation proposed by themselves or the other side is the right one. And the position, as again, I'm sure you can anticipate, could get very complicated. If one of the co-owners says they want to use the land, in other words, they're highlighting, if the co-owner who's interested in buying the land is highlighting their own use in the future of the land, being the reason why they want to buy the land, of course, that may contemplate a scenario where the land is not going to be sold for many years. On the other hand, the land may have development potential. And if the land has development potential, the co-owner who's being bought out might have something to say, and would have something to say, one would imagine, about whether the development potential should be reflected in the price of the land, which of course, if the other co-owner is in fact wanting to use the property and may be very reluctant to pay for, if that doesn't represent, on their view, a true value of what the land is. So there are some complications there, and the factual situation involving those complications arose in the litigation Ray Kingsley, and Jeremy has helpfully flicked up the authorities. The case appeared both in the High Court, that's the first reference, and it then went up to the Court of Appeal. The facts of the case are quite straightforward. A brother and sister running a farming partnership in relation to some extensive farming land. There was no dispute, they're both co-owners, they both owned in equal shares. The brother died, and his widow, as executor of his estate, sought a sale of all of the farm, whereas the sister, who was still involved in the farming business, wished to continue operating her business at the farm. There was a complication about whether there was a partnership and the partnership needed to be dissolved, but that doesn't affect us for present purposes. The sister wanted to keep the land intact and indeed aimed to buy out the estate by their half share. So it provides, in the Court of Appeal, and indeed the first instance case as well, that they provide valuable guidance as to how to approach this type of situation. And needless to say, the first point made was that the usual order in all these cases, and the primary focus, will be on an order for sale in order to give proper market value as the touchstone for when the trust is broken up on the sale. However, notwithstanding that, it is possible, although it's said to be unusual, it is possible to give one co-owner the right to buy out. And when considering that possibility, one of the factors under Section 15, which the court must consider, is the risk that the co-owner who is bought out is getting less than proper value. That is a factor that has to be considered. On the facts, in this case, farmland versus farmland worth 3.2 million, where value has been brought in by both sides to value the land, and the farmland was roughly 3.2 million. The court decided that although there was development potential in the land, that was not something that needed to be reflected in an overage payment, which is something that the estate had argued for. That was not something that needed to be reflected in an overage payment. And the court was prepared to satisfied that the value was sufficiently certain, looking at development on the basis merely of hope value in the future, provided a more certain figure and potentially a lower figure. And on that basis, the court were prepared to give the sister the right to buy out the co-owning share. In terms of practicalities, what therefore is important if you have a case where one co-owner, your client is trying to buy out the other side, you'd certainly read these two cases, in particular the Court of Appeal case. Very valuable guidance given there, and the obvious point that you need to have a valuer who's going to be strong and ensure that there is not too much doubt about the value and issues arising on value. That in the case of a single property, certainly a domestic property, is unlikely to be a problem. Obviously in the country where the estate is larger and the different parts to the land, that as in the Kingsley case, is likely to be more of a problem. We want a strong valuer who's going to be able to deal with any arguments that the other side valuer comes up with, possibly to say that it's either uncertain or indeed much lower than the true value. And of course, the flip side of that coin is that the greater the doubt about value, the less likely your client will be to obtain an order for a right to buy out. And the more tempted the court will be in the circumstances to give a straight order for sale. Just as a last point on that, it was argued in the Court of Appeal that effectively any form of, or any significant form of uncertainty about the true value of the land would effectively interfere with the co-owner who's being bought out, their human rights. It would be effectively a deprivation of their property in respect of that part of the value that they're not certainly acquiring on the buyout. Perhaps unsurprisingly these days, that was given fairly short shrift by the Court of Appeal. This process is a proportionate process, key word, proportionality these days in human rights cases. It's a proportionate process. The court take into account all of the factors in Section 15, and in those circumstances, that is not an unlawful interference with human right involved. So that was the Kingsley case. I turn now to the second situation I'm going to deal with. And this is, in a sense, going back to the very opposite end of the problem. It's not the problem when you're either issuing and considering what order to seek, and or when you're fighting once the case is issued, fighting about the type of order that's appropriate in the case. This goes back right to the very start of an ownership stroke co-ownership dispute. Yeah, I'm not thinking here of a quasi-matrimonial or matrimonial type of property, but I'm thinking of the sorts of arrangements that you have in families or people who are close to each other, friends, where people with the ability to obtain a mortgage or ready funds, are assisting a friend, somebody who's close to them at that time, to acquire a property, albeit that that friend who will be occupying the property and paying money, albeit that that friend will not actually be formally either on the mortgage document or on any of the formal property documents. And of course, this can happen 20, 25 years ago. And then, of course, something happens either quickly or slowly, the relationship deteriorates. And then suddenly we find a picture whereby, albeit one of the parties is saying they're the sole owner, the other party, the trustee party, the owner is saying all the payments are effectively have been rent, and that in fact the person who's occupying the property is only a tenant, and or everything else is explained by way of informal relationship and the like. A very, very common situation. It's common not only in and of itself where the dispute is solely about that, it's also common where parties have more than one property, and although they may be cohabiting in one property, there are a little portfolio of other properties, and specific arrangements have been made for one or t'other party to have the property in their name for whatever reason. And this, for that reason, is very, as I say, is not uncommon, and we have interesting case law on it as to what is the right approach to use when analysing the ownership. And what I want to talk about today is there are a couple of relevant cases to this particular subject. The particular case which Jeremy will have flashed up there is the Tahir and Faizi case. That's the case. If you've got a case which is on this point, this is the case that might be interesting and worth reading. Not necessarily because you should slavishly follow the approach. In fact, for the opposite. I'm going to say that the approach is a slightly surprising approach in that case. The reason why I'm picking this out is because there seems to be in this area, the tools that as lawyers we have to resolve ownership of property where there is some form of dispute, leaving aside an express trust or a clear contract that deals with ownership. The main tools that we have are the resulting trust and the common intention constructive trust. They're quite different. The resulting trust is based in this type of situation on financial contributions to the purchase price, whereas the common intention constructive trust is based on an express agreement about ownership coupled together with detriment or reliance and detriment or change of position, or an express agreement which will effectively infer an arising out of financial contributions. Now, the classic case on that is, of course, the Lloyds Bank and Rossett case. Just a couple of preliminary points to make about Lloyds Bank and Rossett. I always think that Lloyds Bank and Rossett actually seems to link through to resulting trust, and that's why I find a lot of the recent discussion of these two methods of approaching the problem a little bit odd, because you don't often see reference to the fact that resulting trust is fueled by contribution to purchase price, and on the other hand, common intention and constructive trust on the second limb in Lloyds Bank and Rossett, where you are entitled to infer a common intention and constructive trust, again, is fueled by financial contribution to the purchase price. I mean, it's obvious that the two things are the same sort of thing, and obviously they will very often both apply in a situation where there is a financial contribution. The confusion, if it is a confusion, and perhaps it's very wrong for me to express it quite like that, but the confusion arises, I think, where from Stack and Dowden, where the House of Lords tried to iron out problems in this area, problems of approach, and then while they obviously have laid down some very clear guidance in one area in co-owned property, was a lot of dicta, not strictly speaking relevant to the case, a lot of dicta suggesting that resulting trust should really be kept to commercial situations, whereas common intention constructive trust is really what one should be looking at for matrimonial cases and quasi-matrimonial cases. But in my view, again, we all probably have our own personal views on this, but in my view, quite a rough and ready way of approaching both of these legal tools. There may have been very good reasons, maybe I'm missing it, but quite a rough and ready way of separating out those two tools when dealing with situations. And it seems to me that has created a little bit of confusion about what sorts of legal tools we should be using when we're dealing with ownership disputes. And I think Tahir and Fizi might be an example of the confusion that has been created. The case itself, just to explain, I've explained it in outline. It's the idea of one person taking all the commitments on behalf of another. Just to explain, this was a case where the sole owner bought the property in 2006 with the benefit of mortgage, and his friend moved in there. He didn't have immigration status at the time, so for that reason, he was simply, for whatever the precise reasons are, he was not able to buy the property. Wouldn't have been able to get a mortgage. There might have been problems with that, and in those circumstances, they reached that arrangement. Of course, down the line, after the friend who'd gone into occupation had paid money, either directly to the mortgagee or to his friend, who then paid the mortgagee, and this person had also done improvements on the property. A number of years later, of course, they fell out, and the person who owned the property characterised the arrangement as a tenancy, and that any money changing hands was to do with rent arrears rather than the more fundamental arrangement alleged on the other side. And the reason why I'm drawing your attention to this case is because it's very interesting that this case was decided by way of resulting trust. The decision in the end, just to get to that and get that out of the way, was that the person who was living in the property was not, whose name was the co-owner, who was not co-owner, the person who was living in the property won the case on resulting trust principles. They were said to have acquired an interest by reference to financial contributions and the like on resulting trust principles. However, that seems to me a surprising result. What is equally surprising is that common intention constructive trust was actually talked about. It was talked about by the trial judge. It's interesting to read the judgment, which is in the Queen's Bench division. It's an appeal case on appeal from a county court judge. County court judge went through the law and said, on the one hand, you'll find this at paragraphs 25 to 28. On the one hand, he said there are quasi-matrimonial homes, and Stack and Dowden talks about the application of the common intention constructive trust. He then goes, and I'm going to just quickly look at the judgment itself. He says that's the first category, Stack and Dowden. He says there's a second category of case, which are commercial cases, and for that it's entirely different. And then you've got a third category of case, which sits somewhere in between, and it's unclear what one does about those. They may have resulting trust, constructive trust elements. Now, that on its face is not an unreasonable analysis, I think, of this type of situation. And yet, in the appeal case, at paragraph 47, and I read, the judge said, I'll read it out. The parties also agreed that a common intention constructive trust does not arise on the facts of this case. Given the context, this is not the case. This is not a case purchase of a shared home, as in Stack and Dowden and Jones and Kernot. I agree that the common intention constructive trust does not arise on the facts of this case. Now, the only reason I'm mentioning this is because if you had come to the law cold and followed that, I think that would be very misleading. I think it's difficult to think of a situation that more clearly cries out as being a common intention constructive trust case than the facts of this. And I'm slightly hesitant about saying this because, of course, one doesn't always know all of the background information, and there may be some factor that exists that's not immediately apparent on the face of the judgment that suggests that it wasn't a common intention constructive trust. But there it is. On the face of this looks like a common intention constructive trust. And yet the court was saying that despite the fact there was an obvious arrangement, and despite the fact that the owner who went in there and then paid all that money as either rent and did all the improvements, all of that done allegedly on the basis of this arrangement, that surely that was detriment which sufficed to support a common intention constructive trust. And I suggest, even if you just put that aside and treat it as an interesting case, I emphasize it is absolutely clear that common intention constructive trust is relevant as a tool that you can use outside of the quasi-matrimonial or matrimonial home case. And there is another very recent case, and this is in the Court of Appeal, and it's the last case on the list there, Carman versus Harrigan Morgan. This is a case which just says precisely that. I mean, of course, Lewin on trusts says precisely that. McGarry and Wade on law of property says precisely that. I'm just going to read out one sentence. It says, there is no reason why constructive trusts of a traditional kind may not arise in a commercial context. Now, of course, they're talking there about a purely commercial context. The context in the Tahir and Faisi case wasn't really a purely commercial context. It was much more of a domestic context. And of course, it concerned a residential home. And of course, it was an arrangement between friends which had a high degree of informality associated with the arrangement. Not informality in result, but in terms of the nature of the way that the parties were dealing with each other. So just be careful of Tahir and Faisi, and indeed the Stack and Dowden injunction about the separation of resulting trust and common intention constructive trust. I think Jeremy's probably going to come back to that with one or two cases as well. So finally, I'm just going to do a roundup on three. I just mentioned three cases which are of some interest, and if of course you've got something that you're dealing with at the moment which has these sorts of issues that might be worth quickly looking at. The first case is it's the fourth case mentioned on there. That's the Shilabir and Lanceley case. This is a case where the former partner of the deceased person who died intestate was essentially asked to pay occupation rent after the death of their partner, and the estate of the deceased sought rent for a period of about 2 years from the partner who carried on living in the quasi-matrimonial home. I don't want to take you to, there are no detailed facts in particular that it's very much on its own facts. Just to remind you, where a claim is made for occupation rent, there are actually two situations to consider. The first situation is where there is more than one beneficiary who has a right to occupy under TOLATA, the Act. In that situation, an occupation rent essentially will be decided under the principles set out in the Act. Those are broad. It's under the Act. Alternatively, where there is only one person who has a right to occupy, then that person, the right to obtain an occupation rent from that person is decided by a court if there's a dispute on principles of equity, general equity. And that, of course, was the reason I mentioned that because that, of course, was what happened in Shilabir and Lanceley. It was a case under the second category. The court had to decide whether on general equitable principles, and it's a very broad discretion, whether the widow in that particular case should pay an occupation rent for about 2 years after the death of her partner. The court held the widow should. The widow was, and just note this, the widow was given a period of 3 months grace to find alternative accommodation. So if you have a case where there's an issue about whether you have to pay an occupation rent, you're acting for a client in that type of situation, no occupation rent will be payable for a reasonable period of time, reasonably short period of time, allowing the co-owner concerned to move on. Otherwise, after that period of time, if that co-owner wants to stay, they will have to pay a rent in relation to the property. That's the Schiller case. Just two more cases, quite brief cases. Both turn very substantially on their own facts. We're on the second sheet now. The first case is Martin versus Martin. This is a classic dispute under TOLATA as to whether an order of sale should be made. Slightly more complicated. Both parties were looking for an order of sale and partition. It was two brothers, dispute between two brothers. They both had shares. They inherited this arable pasture and woodland from their father and grandfather. They fell out badly. One brother wanted to sell most of the land, but also that he wanted also that each of them would retain a small portion of land. The other brother, I hope I'm not being unfair, who seemed to be a little bit more disagreeable about everything, wanted most of the land to be retained and to be used as a wildlife haven. And also he wanted a different scheme. Some land could be sold, and a different scheme regarding partition. And in particular, he wanted the land to be parted so that he would retain a boundary on the land that he would have. There would be a boundary between him and the boundary and the land which his brother would get after this partition. In other words, there would be a boundary between their two parts of land. Well, an interesting case. It turns totally on its facts. The court looked at all the background of the trust, the purpose of the trust, the intention of the father, looked at whether there was any wildlife or conservation interest apparent in any of the history of the matter, which there wasn't, and concluded very much against the brother, who I've called the disagreeable one. Apologies to him for that. Very much against him that his scheme was really not the right scheme to have at all. And in particular, this may have some relevance where if you have a client who's seeking some partition of land, a very useful tool in addition to, or indeed in substitution for a pure order for sale, but a partition. But the reason why perhaps it's not so common will be apparent in a second. The court focused on the fact that there would be a partition with the two warring brothers still having a boundary between them, and said that the court concluded that was entirely inappropriate and there would be no partition like that. And of course, that's probably right about most co-ownership disputes, that if the two parties have really fallen out very badly and one party is seeking a partition rather than a sale, the court's got to take into account the quite obvious inappropriateness of two people who have been not getting on for a while, or really there's animosity there, being divided by a boundary in land. That's a recipe for a problem. So that's the case of Martin and Martin. And lastly, Gandisha, case of Gandisha, which is the last case on the list of cases. Very unusual facts again, very interesting. Possibly quite extreme. 5 brothers bought a property for themselves and their families to live in, and that's perhaps not so unusual at all. That's not an unusual thing for families to live together like that. But with some foresight a trust deed was entered into, which laid out the difficulties that there would be if in the future as regards the sale of that land. It was done as a trust for sale with a power to postpone a sale, which is an old style trust for sale there, but it was done expressly in a trust. But in particular, the land was not to be sold while any one of them was alive unless the survivors were unanimous. And also a clause saying that no sole party could demand a sale. So both of those clauses were very strong fetters against impeding sale of the land. Now, if this was a quiz show, it would be, well, and what happened next? Or a question of sport, what happened next? Well, there was, of course, a huge fallout amongst the brothers. At least 2 of the brothers left with their families to live elsewhere. And what happened next? The 2 brothers who went to live elsewhere eventually wanted to get a sale of the land because their interest was tied up in the property where the other 3 brothers and their families, warring families, were living. 2 brothers wanted an order for sale. And the question was, well, should there be an order for sale in the context of the trust deed that the 5 families had entered into. Quite unusual. And the Court of Appeal, I hope I haven't remembered that incorrectly. I beg your pardon, it's the Queen's Bench Division considered that. Very interesting, looking at the trust deed, and perhaps not entirely surprising conclusion that on the true construction of the deed, as a matter of implication, the partners, the brothers could not have intended, in fact, these clauses to have had such a draconian effect. They must have intended, in effect, that if there was a breakdown, the purposes of the trust would effectively have been fallen away, in which case the trust for sale would then kick in. And that is the way that the court decided the case. The trust did not impede an order for sale, and an order for sale was made, giving effect essentially to a common sense, arguably a common sense conclusion, notwithstanding the legal document that was in place to prevent that. So I hand over now to the slightly more focused quasi-matrimonial part of the talk now, and Jeremy.
Thanks. Thank you, Desmond. And I hope you can all hear me and see me. Before I forget, can I just remind everyone that our next webinar is on the 12th of January, and it's a private family law update from our very own Francis Cassidy, and I'll mention that at the end as well. But that's our next event. Right. Well, I'm just going to scoot through a couple of cases that involve us family practitioners, particularly. I won't be long. I'm going to start with a case which is one of those which involves the difficulty in establishing a beneficial interest in a property that is in another's sole name, where there's been no express agreement or unclear financial contributions. And these sorts of cases are difficult. They make for difficult advice to have to be given to a client sometimes. And it's a sort of case that's led perhaps to the most clamour for a change in the law. And the case of Pillmore and Meyer is a recent example of one of these cases. Let me just get the citation up for you. No. I'm so sorry. There's, let me see if, yes, there it is. I hope you can see that. Now, the case of Pillmore and Meyer was decided a year ago. I hope you forgive me for mentioning it, as it's an interesting case and worth catching up on if you haven't read it yet. It essentially decides that only in very exceptional circumstances can the parties' conduct give rise to a finding of mutual intention to share ownership. And on the facts, it's quite a harsh decision, I think. And maybe you'll agree with me. The husband and wife were married for about 30 years. They lived at a property in the northeast of England together since the early 90s. In fact, they had several children who had grown up at the date of the hearing. And the legal title of the property was held by the husband, and the mortgage was in his sole name as well. They were partners, the husband and wife, in a food shop, together with the husband's parents. And the husband went bankrupt, and the trustee in bankruptcy made a claim for possession of the house. And that was resisted by the wife, who claimed a beneficial interest in it, unsurprisingly, under a common intention constructive trust. And at first instance, the trial judge found that there was no, importantly, that there was no express discussion or agreement about the wife sharing ownership of the property. But he nonetheless deduced objectively from their conduct that a common intention could be found to share beneficial ownership, and gave her 50% of the property as against the trustee in bankruptcy. And in so doing, the judge at first instance was persuaded by the fact that the wife understood that she would have a share in the property, and importantly, that there was some financial contribution towards the house by the family business, towards which the wife had made a non-financial contribution, and reading between the lines, maybe working in the shop, helping out with the books and so on. Further, it was found culturally normal for the husband to take the financial lead in the family and in their community. And of course, the house was acquired as a family home and lived in as a family for an extensive period. And so he found that she should have half share in it. And I'm sure all of us practitioners would go, well, that sounds fair. But on appeal, the trustee in bankruptcy appealed to the High Court, and Judge Kramer really homed in on the important difference between the evidence in support of an inference of an agreement on the one hand, as opposed to the evidence in support of the reliance on a supposed agreement, and not to conflate the two. I mean, often the evidence is the same thing, isn't it? And I mean, laying out significant sums to build an extension, which that was an example that was given in this case. But in relation to that, to the evidence needed in support of an inference of an agreement itself, Judge Kramer relied very much on the strict application of Lord Bridges' judgment in Lloyd Bank and Rossett, that neither a common intention by spouses that a house is to be renovated as a joint venture, nor a common intention that the house is to be shared by the parents and children as a family home, throws any light on their intentions. And Lord Bridges, as we know, went on to say that where there's no evidence of express agreement or discussion, and the court must therefore rely entirely on conduct, then direct contributions to the purchase price will readily justify the inference, but extremely doubtful that anything else will do. So the judge allowed the appeal, determining that the poor wife owned no beneficial interest at all. And in doing so, he found that playing a part in supporting the family business, from which contributions to the purchase of the property was clearly funded, wasn't enough. Nor, of course, acquiring the property as a family home and living in it for decades. And he cited the words of Lord Walker in Stack and Dowden. Whether or not Lord Bridges' observation was justified in 1990, in my opinion, the law has moved on. Well, clearly in the eyes of Judge Kramer at least, not moved on so much in the establishment of beneficial interest, rather that moving on was applicable to the quantification. So it's quite, I mean, it's an interesting case, and may be helpful if you're fighting off one of these claims to a common intention constructive trust, where the financial contributions are, best opaque. Then, just moving quickly on, the next broad heading is the employment of a resulting trust. Quite an interesting case called Solomon and McCarthy. And I'm going to try and get this back up onto the screen. Forgive me if I hope you can see that. I'll give you the citation. It's Solomon and McCarthy, 2020, 1 PNCR DG 22. But if you just Google the name, the report will come up in case mine and other resources. It's I think it was a Bristol-based case. There were two properties, both in the claimant's name. She sought declarations that they were each beneficially owned in equal shares with her ex-partner. She didn't contest that the first property was beneficially owned as to 50% each. There was an equitable accounting argument where the evidence was clearly rubbish. I mean, the defendant who was claiming for equitable accounting produced almost no evidence to support his contention. I won't go into the detail of that, but it's worth having a look at if you're involved in an equitable accounting case. It was also a case where the parties were devoting a lot of energy to alleging bad conduct, and the judge was having none of that. I mean, how many cases do we have in this field where you've got a lot of really irrelevant allegations going on? It's quite a good authority. Quite a good case illustration, really to try and get rid of those sorts of peripheral issues. The defendant argued that the second property was held by the claimant on trust for their two sons. And this is a unique aspect of this case. The judge held that in circumstances where a property was transferred by A to B, from the father to the mother of those adult sons, with the intention that the beneficial interest was to be held by the sons, and that wasn't committed to writing, which it wasn't, and therefore fell foul, in the judge's view, of the writing requirement of section 53(1) of the LPA, then in those circumstances, the beneficial interest reverted to the defendant under resulting trust. So it's an interesting example, but Desmond was touching on this, of a resulting trust application in a domestic context. The next case, Secretary of State for Work and Pensions and Tower Hamlets. Again, I hope you can see this. I'm sorry about my technical incompetence. The citation is 2018 UK UT 25. Concerns an appeal brought by claimants against the London Borough of Tower Hamlets. It involved a claim to have a housing benefit, and Tower Hamlets, the local authority, said you're not entitled to housing benefits because you own a property that's worth more than £6,000. She disputed that. The property was in her name. She had bought it with a boyfriend, and I think the relationship lasted about a week. But she managed to cajole him into forking out about £60,000 or £70,000 to buy the house, which went into her name, and the mortgage was in her name. And she claimed, no, there's a resulting trust to my friend, my erstwhile boyfriend, who put up all this money, and I only own the amount that I put in, which was 250 quid. And the court, both at first instance, it was the first instance tribunal, the first tier tribunal in these social security appeals, and the appeal court agreed with her. So another example of a resulting trust. I mean, it was a quasi-family context because it was seen as an investment. And even though the mortgage was in her name, and that she organised the payment of the mortgage from the rent from that property, it still, the court found, did not give her a greater interest, and the resulting trust in terms of the amount of money they put in to start with prevailed. So have a look at that. The last two cases I'm going to mention are, I would describe as interesting cases in that they are judgments of courts that are wrestling with how to sort out assets where those assets are limited. So it perhaps has more application to the family remedy practitioners amongst us. And they are, again, apologies for the size of the screen share. But it's the case of Cliers and Cliers, K-L-I-E-R-S, 2020 England and Wales High Court decision on Bailey 1026. And the second case being V&W, again this year, England and Wales Family Court, EWFC 25. Just dealing with the first of those cases. I mean, extraordinary background facts, but essentially it concerns an application for sale following the determination of a TOLATA application in which the wife was found to have a 75% interest, beneficial interest in the house, and the husband a 25% interest. The factual background included a significant element of fraud in that the property was put into the name of a brother to enable housing benefit and other benefits to be claimed over a lengthy period. When, as the court found, in fact, the brother was a bare trustee. Shortly after the TOLATA hearing, the husband, who was still living in the house with his new wife and children, was applied for financial remedies within divorce proceedings, and it came before Nicholas Cusworth QC, sitting as a Deputy High Court judge. And the dispute was, should he order sale and in what proportions? It was only months previous to the case that the Chancery Division had decided that there was a 75%, 25% split in the wife's favour. Within the divorce jurisdiction, no, said the judge, sale discharged the joint debts, including a huge debt from wrongly claimed housing benefit, proceeds split 50-50. In other words, departed from those strict beneficial interest division in the previous TOLATA proceedings. So interesting from that to that extent. And it's of interest to us family remedy practitioners, if any of us here tonight, because it's a rare example of a high court wrestling with modest assets. This sort of case that hardly ever gets reported. And the last case I'm going to mention is that case of V&W. It's another recent case decided over lockdown. It's worth having a look at, not because it says anything particularly striking about the law, but it's a good case illustration of the court wrestling with two jurisdictions at the same time, TOLATA and Schedule 1. It sometimes happens, doesn't it? Somebody perceives that their case is a bit rubbish under TOLATA, but they'll stick in a Schedule 1 application for good measure. And that was, in fact, both claims in this case had legs, and the court, we read in that judgment, applying the differing principles under those two acts and determining whether the house is sold and so on. So that was an interesting example of that. That's all I'm going to say at this stage. I hope, Desmond, you're still there, because I'm planning, in case we have any difficult questions, to get you to answer them. But we do have some questions, actually.
I think you have the right to buy me out on that one.
Just a couple, and then we'll let everyone go off and do whatever they've got planned for the evening. But here's one. Are resulting trusts, well, we've to an extent answered this, I suppose, but are resulting trusts ever relevant in a matrimonial context? That's one question. I've got another one here. Can trustees partition land under the provisions of TOLATA where there are two co-owners? So do you want to think about either of those?
I think the first question, I think actually that reflects something that we talked about earlier on, and in particular the Tahir and Faizi case. Yeah. I think something that I hope I've made it clear, and if not, I'd emphasise this now. What Stack and Dowden was saying that was resulting, and this was quite strong, I think, is that resulting trust should really be left on the commercial side, at the commercial end of the range of these disputes. So when you've got a quasi-matrimonial home or matrimonial home, it really should be dealt with using a common intention resulting trust. And as I did say, of course, if all you've got is direct financial contributions, yes, that's like a resulting trust, but it's the second limb of Lloyds Bank and Rossett, which is common intention resulting trust. Okay. What I was trying to emphasize is that in drawing that distinction between resulting trust and common intention resulting trust in the context of quasi-matrimonial homes, it shouldn't follow that therefore common intention resulting trust isn't relevant across the range through to commercial disputes. And that appeared to be what Tahir and Faizi was concluding. So that, I just repeat that again. I hope that answers that question. The second question about partition, right. The trustees unfortunately will not be able to carry out under the Act. They can only partition land. So rather than going to court, the trustees could sort this out if all the beneficiaries agree. I think that's the short answer. So if everybody agrees, then you can do the partition. The trustees have power to do that. But if there's not unanimous agreement, then the trustees have to go to court to get the court, which certainly can order a partition in the face of opposition by one of the relevant beneficiaries. And obviously, if you have that type of situation, in order to try and reduce your cost risk, you'll be writing all those letters saying, proposing all the relevant partitions and possibly providing a range of options for the other side and being as generous and sensible as possible in order to reduce your litigation risk. But you do have to go to court.
Great. Okay, thanks, Desmond. And thank you very much to everyone who's tuned in. And just a reminder, our next one is on the 12th of January, Francis Cassidy on Private Law Family Update. We're having a break for Christmas otherwise. Have a great December, everyone, and see you soon. Thank you.